Civilizations decay in their language before their walls. When accusation replaces analysis, repetition replaces verification, and certainty replaces discipline. In court, where liberty, property, and reputation are at stake, language still has rank. Allegations are not evidence, and evidence is not proof. Confuse this and you will misunderstand outcomes, misjudge cases, and misinterpret dismissals. Time to restore order, not emotion, not outrage, but order.
Consider a familiar modern scenario. A public accusation appears online. He committed fraud. Within hours, thousands react. People post screenshots. Others say, "There's proof everywhere." Conclusions are drawn. Reputations shift. Now imagine the same accusation is filed in federal court, and weeks later, the case is dismissed before trial. Observers often respond with confusion or suspicion. How can that be? There was evidence. Everyone saw it. The answer lies in a misunderstanding of structure. The federal civil system operates in stages, and each stage has its own function. Allegations begin the case, evidence is gathered and tested, then proof is measured against a defined legal standard. These are not interchangeable ideas. They are procedural checkpoints embedded directly into the federal rules of civil procedure. If you collapse them into one category, if you treat accusation as proof, you will consistently misread the system. This discussion is not about defending wrongdoing. It is about understanding process. Process is what separates structured justice from reaction. An allegation is an assertion that something happened. It is a statement of fact claimed by a party. This is the legal starting point. It is not verified. It is not weighed. It is not adjudicated. In federal court, allegations appear in a complaint. The governing rule is Rule 8 of the Federal Rules of Civil Procedure. Rule 8 requires a short and plain statement of the claim, showing that the pleader is entitled to relief. That language is important. The rule does not require proof. It requires sufficient factual allegations to show entitlement to relief if those facts are true. At this stage, courts do something specific and limited. When evaluating a motion to dismiss, they assume factual allegations are true solely for purposes of testing legal sufficiency. That assumption is procedural, not factual endorsement. The court is not saying, "We believe you." The court is saying, "If we temporarily accept this as true, does the law provide a remedy?" If the answer is no, dismissal follows. That mechanism exists under Rule 12b-6, failure to state a claim upon which relief can be granted. Rule 12b-6 serves a gatekeeping function. It prevents litigation from proceeding when the complaint does not allege facts that satisfy the legal elements of a recognized cause of action. This is where many cases end, not because the allegations are necessarily false, but because they are legally insufficient. For example, if a plaintiff alleges unfair treatment, but fails to allege facts establishing a legally protected right that was violated, the complaint may be dismissed even if the treatment felt wrong. Courts evaluate whether the alleged facts, taken as true, plausibly support each required legal element. This stage is about structure, not truth determination. A compelling narrative without legally required elements fails. A technically structured complaint with minimal storytelling may survive. Allegations open the door. They do not win the case. If a complaint survives Rule 12b-6, the case enters discovery, which is governed primarily by Rule 26. Rule 26 establishes the framework for exchanging information relevant to claims and defenses. It allows parties to obtain documents, take depositions, submit interrogatories, and request admissions. This is where evidence is gathered. Evidence may include sworn testimony, business records, contracts, emails and electronic communications, financial records, photographs, and expert reports. However, not everything produced in discovery automatically becomes admissible at trial. Evidence must satisfy rules of admissibility, including relevance and reliability. While the federal rules of evidence govern admissibility in detail, The core principle is simple. Evidence must be trustworthy and related to a material issue. Common misconceptions arise here. Volume is not strength, emotion is not relevance, and suspicion is not proof. Consider digital evidence. A screenshot may appear convincing, but courts require authentication. Proof that the document is what it claims to be and has not been altered. Context matters. Partial statements can mislead. Communications must be understood within their full exchange. Additionally, some statements may be excluded as hearsay if offered to prove the truth of what was asserted, and no exception applies. Discovery is not a verdict phase. It is an information phase. The purpose is to gather material that might support a claim or defense. But evidence alone does not guarantee success. Evidence must be sufficient to satisfy the burden of proof. That determination occurs at the next stage. Proof involves persuasion under a defined standard. In civil cases, the plaintiff bears the burden of proof. That burden has two components. 1. The burden of production, presenting enough evidence to allow the claim to proceed. 2. The burden of persuasion, convincing the fact finder that the claim meets the required legal standard. Most civil cases operate under the preponderance of the evidence standard. This means the claim is more likely true than not true, not certainty, not overwhelming evidence, more likely than not. Some cases require clear and convincing evidence, a higher threshold demanding a firm belief in the claim's truth. Criminal cases require proof beyond a reasonable doubt, a significantly higher standard. The existence of evidence does not automatically satisfy these standards. A party may produce documents and witnesses, yet still fail if key elements are unsupported. Witnesses lack credibility, evidence contradicts itself, or legal defenses apply. This becomes particularly visible at the summary judgment stage. Under Rule 56, a party may move for summary judgment if there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. Material facts are facts that could affect the outcome of the case under governing law. If, after discovery, the non-moving party cannot show sufficient evidence for a reasonable jury to find in its favor, the court may enter judgment without a trial. Rule 56 is not about weighing credibility in close cases. It is about determining whether there is enough legally sufficient evidence to justify proceeding to trial. If the evidence cannot meet the burden of proof as a matter of law, the case ends. At trial, Rule 50 permits judgment as a matter of law if a party has been fully heard and the evidence is legally insufficient to support a reasonable verdict. Again, the structure enforces hierarchy. Allegations are filtered, evidence is gathered, and proof is measured. Understanding where cases end clarifies the distinction between these stages. Cases may fail at Rule 12b-6, insufficient allegations. Rule 56, insufficient evidence to create a genuine dispute. Rule 50, insufficient proof at trial. Dismissal does not necessarily mean the underlying events did not occur. It means the legal framework required for recovery was not satisfied. Summary judgment does not mean a judge preferred one party. It means the evidence, even viewed favorably to the non-moving party, did not meet the burden. Appeals further reinforce this hierarchy. Appellate courts generally review legal questions de novo, but review factual determinations under deferential standards. They do not retry cases. They do not accept new evidence. This layered review system ensures that proof is evaluated according to defined legal standards, not emotional reaction. Outside courtrooms, this hierarchy often disappears. Allegations spread instantly, evidence is selectively highlighted, and proof is assumed. Without procedural safeguards, the distinction collapses. This is why the burden of proof exists. It protects against conclusions based solely on accusation. The rules governing admissibility protect against unreliable material. The pleading standard prevents courts from entertaining claims that lack legal grounding. These mechanisms may seem technical, but they serve a broader purpose. They slow down judgment. Slowness in this context is not inefficiency. It is discipline. When you encounter a public controversy, you can apply the same structure. Is this merely an allegation? Is there verified, admissible evidence? Does that evidence meet a defined burden of proof? If those steps are skipped, you are witnessing narrative rather than adjudication. The federal rules of civil procedure reflect a deliberate architecture. Rule 8 establishes the pleading requirement. Rule 12, B6, filters legally insufficient claims. Rule 26 governs discovery and evidence exchange. Rule 56 tests evidentiary sufficiency before trial. Rule 50 ensures legally sufficient proof at trial. Each rule corresponds to a stage in the hierarchy. Allegations initiate, evidence supports, and proof persuades. When these categories are confused, misunderstanding follows. Precision in thinking requires separating them. That separation protects fairness, clarifies outcomes, and promotes disciplined reasoning. Words must retain rank. Allegation is not evidence. Evidence is not proof. Maintain the distinction, and you will understand the system.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.